Welcome to Camp Constitution Radio with your host, Hal Shurtleff. This show is heard on WBCQ The Planet every Monday night at 7:30 p.m. Eastern Standard Time. WBCQ broadcast out of the beautiful town of Monticello, Maine. And I'm actually here in Boston, and I'm with my co-host and colleague, Tom Moor. And just before we introduce our very special guest, I'd like to talk a little bit about the entity that hosts this program. It's Camp Constitution. Among other things, Camp Constitution hosts a week and a day-long summer camp program in Ringe, New Hampshire. Next year's camp will run from July 10th to the 17th. We're lining up some guests already, and we'll have some hopefully announcements in the next few days. But Garrett Lee, the Patriot Pastor, will be one of the speakers, and Mrs. Chris Ann Howell will be returning for the third year. And we are very excited about the Sam Blumenfeld archives, which you can find on our website, campconstitution.net. You'll be able to find a lot of his writings, his alphaphonics. You can actually use the website to teach people how to read, because Sam has, we've been able to upload 128 lessons from his alphaphonics and the alphaphonics itself, the workbook. Anyway, today's guest is Dr. Edwin Vieira, a doctor of law, not of medicine. And you there, Edwin?
Yes, I am.
Well, it's why don't you, instead of me giving a long introduction, why don't you just give yourself give the listeners a little background?
Well, I'm a graduate of Harvard College and the graduate school and the law school, and I've been practicing law since 1973, with an emphasis on constitutional issues, having cases that raise constitutional issues. The courts always don't end up deciding it on that basis. And for the last, quite a few years, I've been writing books on constitutional history, constitutional theory, and really constitutional policy, emphasizing banking and money, and more recently the general area of Homeland Security with a focus on the constitutional militia.
In fact, I have to give you a lot of credit. You've helped me and a lot of other people in the, I guess I can use the word patriot movement or freedom movement or liberty movement. For many years, I thought, foolishly, although I believe that was accurate, I would say use the term unregulated or unorganized militia, thinking that was a true militia. I was simply quoting the federal law. And you pointed out in your book, Constitutional Homeland Security, that there really isn't any such thing. An unorganized militia is much like an unorganized baseball team in the neighborhood. It doesn't really exist. So can you elaborate a little bit on that? And then I want to get into the Article 5 issue.
Well, one of the problems that you have with reading a lot of the federal statutes today is you have to understand that over the years, unconstitutional principles have insinuated themselves one way or another into that statutory body. And actually what happened was at the turn of the 20th century, in 1903, passage of a statute called the Dick Act, after Representative Dick from Ohio, created what we now know as the National Guard. And that statute and subsequent statutes up to about 1916, when the full structure finally appears, attempted to play on the concept of the militia in the Constitution, calling the National Guard the organized militia, and everybody else the unorganized militia. And, of course, an unorganized militia, if you actually look back in American constitutional history and actually the original statutes that were passed by Congress under the Constitution, the concept of unorganized militia is an oxymoron. It's a constitutional impossibility, contradiction in terms. So you have to ask the question, well, what is this thing called the National Guard? Actually, it's the troops or ships of war that the states may keep in time of peace with the consent of Congress. It's a completely different thing under Article 1, Section 10, Clause 3. It's one of the three military or quasi-military structures that the Constitution provides for, the Army and the Navy at the level of the general government in Washington, D.C., the National Guard, which is this peculiar middle ground. It's state troops, but Congress has to consent to how that's structured. And then there is the constitutional militia, which are permanent parts of the federal system. And as a result of that series of statutes from 1903 to 1916, of course, they've subsequently added to it, the true constitutional militia essentially atrophied. And you find in every state where I've looked this basic structure. There's the National Guard, and then some states have a thing called the State Defense Force, which is really an adjunct of the National Guard. And then everyone else is dumped into a category called the unorganized militia, which is exactly that. There's no organization, no training, no equipment, no nothing. And as a result of that having happened, this whole category of constitutional structures, because there should be one in every one of the 50 states, has essentially become moribund. I mean, it's just not there. My entire life, whether it was in Rhode Island or Maryland or now Virginia, where I've lived over the years where I should have been part of some kind of active militia structure, I haven't been, simply because statute didn't provide for it and didn't require my participation or really give me any opportunity to participate. My only choice was to become a member of the National Guard, which is essentially a voluntary organization. People sign up for that and enter into contracts, or the regular Army, regular Navy, Air Force, and so on, which, of course, today is all based on volunteer enlistment. So as a result...
And also the Army Reserve, which I have belonged to.
Right, or the Army Reserve, right? If you've been in the Army, you can go into the Army Reserve, or the Naval Reserve, Marine Corps Reserve, whatever. But those are also subsets of the regular armed forces structure. And so as a result of that, we have a Homeland Security structure in which those institutions which the Constitution sees as central are not there. Congress has simply left them out of the picture, and so have the states, because the states are pretty much responding to the statutory structure that Congress has created. And instead of the Homeland Security functions that the constitutional militia should be performing, we now have a kind of quasi-standing army built up of state police, local police, county police, city police, whatever they are, all professional organizations, and then various emergency management structures that have been created at the state level. All of those being tied into one or another of the branches now of the Department of Homeland Security.
Edwin, practical question on that note before you pass to the next one. So we are just finishing now, this past September, the several-month Jade Helm exercises, basically urban warfare, and so you have regular Army troops in the streets of America. Could such a thing have happened back in the early 1800s under the militia, and really should they happen? Is this something that really the Army should be able to drill like that or not?
Well, the Army certainly should. Well, it depends what the purpose of the drill is, all right? Some of the propaganda that they're putting out is, well, this is to train our people so when they go overseas, they will be able to meet certain contingencies. But the environment in which they're training them is probably nothing like the type of environment that they might meet, let's say, in the Middle East or in Africa, some of these countries where we have troops deployed or thinking about deploying troops. And so the picture immediately comes to mind that the contingency for which they're planning is some kind of major breakdown, social breakdown in the United States, in which regular armed forces troops would be put into the streets. And that would be what a lot of people would call a martial law situation. And, of course, if you look at the Constitution, there is no provision in the Constitution for the Army exercising any kind of martial law within the United States. If you think through the concept of martial law as a generality, a military or quasi-military or paramilitary organization executing the laws within this country, and you look in the Constitution, well, the only place where you'll find something like that is Article 1, Section 8, Clause 15. Congress has the power to provide for calling forth the militia to execute the laws of the Union. And those laws of the Union would, of course, include the Constitution. So you would have the militia executing the various statutory laws, but always being bound by the Constitution. Whereas the theory of martial law that you see bruited about normally is that the military people come in and they operate according to something called martial law or military law, which they claim is really not bound by the Constitution. Completely different situation entirely. So I would say, to the extent that these military exercises are really fronts for someone's thinking in the Pentagon or in the Department of Homeland Security, they're going to use the regular Army to set up some kind of martial law condition, say in urban areas. If they have an economic breakdown, you get a lot of social unrest and civil disobedience. That's plainly unconstitutional. And if you go back to the Declaration of Independence, the attempt to supplant the civil power, which ultimately the militia is, because it's composed of all the people, the attempt to supplant the civil power with military power, military authority, martial law, as most people use that term, was one of the major indictments against King George III. Declaration of Independence treated that as an example of the tyranny of the king. So it's a little bit difficult to imagine that the same people that were involved in writing the Declaration of Independence and winning the War of Independence would then turn around and put into the Constitution a power which they had excoriated the king for attempting to exercise. And, of course, they didn't, because they left that power to execute the laws of the Union by a martial institution, an armed institution. They left that to the militia of the several states, which are composed, in principle, constitutional principle, of all of the people. Not
right, and that brings us to our second topic of conversation. They did such a wonderful job at the Constitutional Convention. However, they went way beyond what most people thought they were going to do in throwing out the Articles of Confederation. So we this item is right on the front burner in a lot of states, including Massachusetts. We're fighting it this month. Dr. Vieira, can you explain to us, in your mind, the dangers of a constitutional convention? Can it be limited or not?
Well, it depends in terms of what you mean by limitation. If you look at Article 5, it gives Congress the power to propose amendments by itself, or, on the application of the legislatures of two-thirds of the several states, to call a convention for proposing amendments. And then supposedly those amendments, whatever they are, whichever branch of Article 5 is applied, can be ratified by the legislatures of three-fourths of the states or by conventions in three-fourths of the states, depending on which form of ratification is proposed by Congress. So if you look at that alone, and you say, all right, it's going to follow exactly that pattern, Congress could propose amendments, this convention could propose amendments, and whatever amendments came out of that would go to the states' legislatures or state conventions to be ratified. Of course, the question is, what would those amendments be? Who would the delegates be? What would the procedures that would be used at that convention be? And all of that is essentially up in the air because Article 5 has never been used to call a constitutional convention. And Article 5 does give power to Congress to call the convention. And that power and duty would trigger the so-called necessary and proper clause, that Congress has the power to make all laws which shall be necessary and proper for carrying into execution all powers vested by the Constitution in the government of the United States or any department or officer thereof. So Congress would have the power to call a convention, and I would say to set the terms of that convention. Certainly to say where the delegates would come from, how they would be selected, how long the convention would go on, so forth and so on. And Congress could add its proposals for amendments to that convention, as well as allowing the delegates to come up with amendments.
Congress has tried to pass laws in the past. In fact, in 1979, there was the U.S. Senate subcommittee on the judiciary, headed by Orrin Hatch, held hearings, and in fact, I have one of the few copies of the results of that, about 1,400 pages. And so Congress does indeed think it can pass laws to guide it. They haven't yet. Now, the other question is, let's say they pass these laws. Let's say the states, since I know there's been some bills being introduced that will try to control delegates, but according to the late Judge Robert Bork, he opined that it wouldn't matter because the convention would be able to simply ignore anything that'd be unenforceable either at the state level or the federal level.
Well, that's the second problem. The first problem is Congress could come up with a set of rules for this convention, and that would be a law at the quote-unquote federal level, law of the general government. And then nothing that the states could do could supersede that. States can't come in and essentially nullify a congressional statute. That's Article 6, Clause 2 of the Constitution. So we have first that kind of a problem. Assume that Congress comes up with these rules and regulations for how delegates are going to be chosen and procedures adopted and so forth. So you're going to have a problem right there if the states say, well, wait a minute, no, we want to have those rules determined by either our own state legislatures or we want to have them determined by the delegates themselves when they finally show up at the convention. Then the second problem is, the one that you're raising, that when the delegates show up at the convention, it's conceivable they can say, well, we're not going to follow these congressional rules in whole or in part. We've got some better rules we're going to follow. And we're not going to look at these amendments, perhaps, that the Congress has proposed. We're going to come up with our own amendments. And even worse, we're going to come up with our own ratification procedure in the same way that first Constitutional Convention came up with its own ratification procedure. Remember, the Articles of Confederation, Article 13 said that there could be no changes made in the Articles of Confederation without the unanimous consent of the 13 states at the time. Constitutional Convention comes along and says, no, although we were called to amend the Articles of Confederation, we've come up with a better idea, and we've come up with a new ratification proposal, which is if 9 states ratify our new Constitution, then it will be a Constitution binding those 9 states. And, of course, the theory behind that was, well, the other 4 states, economically speaking, they couldn't be left out, so they would essentially be forced to ratify because of the economic circumstance in which they found themselves, and that's what happened.
And that Rhode Island was the last one. Yeah. Now, there's a few groups out there that are spending all of their time pushing an Article 5. One of them that calls itself conservative is the Convention of States, founded by a man named Mark Meckler and also led by Mike Farris. Mike Farris is the founder of the Homeschool Legal Defense Association, and he's pretty well regarded in many circles. But he has advocated a 50-member Supreme Court to be appointed by states for one 6-year term. And I'm thinking, you want to solve the problem of a runaway federal government, I don't think this is the way to do it. And and Mark Meckler, and he seems to have a very interesting background. He really came on the scene. He was almost like Eisenhower, from a lieutenant colonel to a 4-star general in a few months or a few years. All of a sudden, he becomes the head of the Tea Party Patriots. But he's got some interesting. He's with a group called Living Room Conversations. That he's one of their big supporters, along with Van Jones. And in 2011, at Harvard University, your alma mater, September, I happened to be on hand with our friend Dan McGonigal. There was a 2-day event called Conference on the Constitutional Convention. In fact, they used the term Constitutional Convention, and the Convention of States is confusing people to say that one is not the same as the other, which, of course, is not the case. Just a question of semantics. And at that event, it was co-sponsored by a very left-wing professor at Harvard, Larry Lessig. And Larry Lessig has actually advocated a rewrite of the Constitution. And I actually got him on video. I was there. We weren't allowed to do any videotaping inside, but he's outside talking to the founder of the Young Turks, Cenk Uygur. And Cenk has admitted that the first one was a runaway and that he hopes the next one will be a runaway. If there is a next one, then Larry Lessig affirmed that. So I'm sure you've run into some of these people, and I would say most of the people that sort of latched onto this are well-intentioned, and they're rightfully frustrated about the situation. But people will say, well, what is your plan? So let me ask you that question. What can we do to help rein in? And, of course, it's not just the federal government. The Convention of States people think it's the problems at the federal level. It's at the state level, too. The states have been...
yeah, absolutely. Absolutely. It's at both levels. Because we have the states engaged in all sorts of activities which are unconstitutional on the one hand, and then on the other hand, we have the states cooperating with the federal government, usually because they're receiving payments of one kind or another, in actions taken by the federal government that are unconstitutional. And, of course, we have the federal government imposing things on the states that are unconstitutional. I mean, it is the example we just talked about earlier of the militia, one of the classic examples of a specific constitutional requirement that both Congress and the states have agreed for one reason or another to put on, not to put in the back burner, just to put in the closet, right, and close the door.
Almost like a dead letter.
This has no consequence. And it's interesting because if you look at the Second Amendment, a well-regulated militia being necessary to the security of the free state, obviously the Founding Fathers did not think that the militia could be made superfluous by some determination of Congress. Those 13 words tell you that they didn't believe that. And the constitutional structure is such that those 13 words have a mechanism and a requirement. But get away from the militia for a second. The thing that worries me about this, you have people like Mike Farris. One of the amendments Mike Farris proposed dealt with constitutionalizing what the Supreme Court calls its compelling state interest test.
Yes.
And if you think about the compelling state interest test, this is a dodge that the Supreme Court invented to give the government, at both the state and the federal levels, give the government the opportunity to ride roughshod, essentially, over any part of the Bill of Rights if somebody, basically in the court system eventually, comes up with the notion that there's a compelling state interest for doing this. Well, my heavens, the most compelling state interest at the state level or the federal level is to obey the Constitution, not to override it. And here's Farris claiming he's a constitutionalist, and he's going to propose, or he has proposed, an amendment which now constitutionalizes this made-up doctrine, has no basis in the Constitution at the present, this made-up doctrine which the Supreme Court has used to subvert the doctrines of the Constitution for the last, let's say 40 years now, maybe 50 years now, since the end of the World War II. Right? He's
pushing this thing called the Parental Rights Amendment. I think that's what you're referring to.
And that's where it is. That's where that doctrine occurs. But once it occurs in the Parental Rights Amendment, then it's constitutionalized across the board, because the Supreme Court has used it with respect to all of these constitutional principles in the Bill of Rights. We've seen this again and again and again.
What's interesting about Farris is that he buys, as you said, he buys into the notion of compelling state interest. So when some of us counter by let's get rid of compulsory education laws at the state level, no, the state has a compelling state interest. And in fact, our dear late friend Sam Blumenfeld was at a hearing at some state with Farris, and he brought up that notion of compelling state interest. And when Sam confronted him in a friendly manner, he said if the state has a compelling interest to educate, they should educate instead of indoctrinate, but they're not educating. And that compelling state interest in Massachusetts, when they passed this so-called same-sex marriage, gives the state government roughshod over all affairs with homosexual activity. And in fact, there's a doctor that's lost his job because he simply stated the health effects of health risks of that behavior. And it's almost like a club, this compelling state interest.
Well, it's fascinating to me that someone like Farris, who purports to be a constitutionalist, that the amendment that he would have proposed would be to remove the power of the courts to impose this compelling state interest test. All right? They've been doing it and claiming it's a constitutional principle, which it isn't. All right, fine. If the idea is that you have to pass an amendment to correct an error of the Supreme Court, well, let's correct this error, which has done tremendous harm, right? But they don't talk about that. They talk about constitutionalizing and making this thing now a part of their new Constitution. But I don't worry so much about Michael Farris, because no matter what he thinks, I don't think he's going to be a delegate, or if he is a delegate, that he's going to have much influence. I think the people who are going to end up having influence at this Constitutional Convention, Convention of the States, whatever they want to call it, are going to be the community organizer types that are in the, the moderate Republicans all the way to the leftist Democrats, and with more emphasis on the leftist Democrats. Because people that will get there will be the ones who are trained by the Soros groups, by the Alinsky groups, and so forth and so on. They're going to have the money, they're going to have the training, they're going to have the media propaganda, they're going to have the organization. Right? They're not going to go there as individual delegates. They're going to go there as people who have already networked and know what they want to do. And it is not going to be anything that looks like the U.S. Constitution now. It is not going to be anything that looks like what the founding fathers could conceivably have written. It's going to look like something that comes out of a George Soros think tank. And then I imagine they're also going to give us another form of ratification.
Yeah, I think you made a reference to not just a simple majority of state legislators or state ratifying committees, but possibly a national referendum.
Yeah, possibly a national. And the point is, what if they do that, and they hold all of these procedures, and they hold a referendum or whatever their final system is? Then what's going to happen? Can you imagine that someone could take a case to the Supreme Court that we now have, and the Supreme Court say, "Oh no, we're going to declare all of that to be invalid"? I mean, that in a sense is the only ultimate defense that the Mike Farrises of this world are proposing to us, well, if they don't do it according to what Farris and his people say will happen, that somehow or other there can be litigation that will cause the whole thing to be swept away, when Farris himself tells us that one of the major problems for which we need this constitutional convention is that the state, that the courts are not paying attention to the Constitution.
Mm-hmm.
And so you're going to go to those people to salvage this process if it runs amok? I mean, this is childish reasoning. But that's the bottom line for them. If we get a George Soros brokered convention, and out of it comes the Rexford Guy Tugwell new states constitution, or some constitution that will be proposed by the type of people you've been talking to.
Some of these folks who are diehard, and they call themselves conservatives, or they think they are, and some of them may be, and some of even our friends, like Dan Nitzer, a state rep from New Hampshire, but they have some illusion that they're going to be the majority at this convention. And as Alan Keyes at the same event that you participated in a couple of weeks ago, how are you going to keep out the Bush faction and the Romney faction and the Chris Christie faction that dominate the Republicans? And then, of course, you have Democrats, most of whom really have, not all of them, but a lot of them have contempt and disdain for the Constitution. They look at it as some kind of obsolete document. And that view isn't just shared by Democrats; it's shared by Republicans.
That's right.
If we may recall, was it George W. Bush, made a reference to the Constitution and taking the Lord's name in vain?
Right.
That's his attitude, and of course they can get rid of some of those pestery things like the second and they don't have to get rid of the second formally. What if they just pass an amendment that calls for a national gun registration for the children to prevent events like Oregon?
And I asked the question: where are these delegates coming from? Leave aside the possibility that Congress could come up with a rule for selecting delegates. Then it will be Nancy Pelosi and Harry Reid and so forth and so on who will go. But just assume that Congress says, all right, fine, we'll go to the state. Let the state legislatures choose them. All right? What do we know about the state legislatures in this country? Are they all formed of James Madison types and Jefferson types, or even Alexander Hamilton types?
What's interesting is the Convention of States people tell us that there's a majority of Republican state houses and governorships and all that. And I say, you mean the same ones that gave us that have embraced Common Core and Agenda 21?
That's
and
right.
That refused to, so these are the Republicans. We just like Jeb Bush Republicans, right? Well, we only have 2 minutes left, so why don't you let the listeners know and viewers, because this radio show is posted on YouTube as well on the Camp Constitution YouTube channel. Where can we find out information about your writings? I know that you've written some incredible books, some very short ones and some very long ones. Right. So where could people go? And what would you recommend?
Well, there are two basic sources. One, you can go to a website, newswithviews.com. One word, newswithviews.com. On the home page is a list of contributors. Scroll down there to my name, click on that, and you'll get a complete archive there going back to 2005. If you go to Amazon.com and put in my name, then all of the books that I now have available will come up very, very quickly, including books dealing with monetary economics, constitutional monetary questions, and then quite a few dealing with this militia issue, which I think is the thing we really have to worry about. In a sense, I'm not ultimately worried about the Constitutional Convention because I think we're going to have a major economic and political crisis before that thing ever comes to fruition.
Well, we're
going to have to deal with that. Now, the fear I have, though, is that kind of a crisis could generate more enthusiasm for a Constitutional Convention. People will come out and say, look, we wouldn't be in this crisis if the Constitution were workable. We need something new. So the two may play hand in hand, but I think that before that Constitutional Convention lays some new document before the country, we're going to have to deal with this other major problem.
Well, Edwin, we're running out of time, so I want to thank you so much, and thank you for listening. God bless, and we'll see you next week.
Appreciate it. Thank you.
Okay, bye. You've been listening to Camp Constitution Radio on WBCQ The Planet, heard every Monday night at 7:30 p.m. Eastern Standard Time.